What is the difference between an RFE, which is a request for evidence, and an RFIE, which is a request for initial evidence? Hello friends, I hope you're all doing great. My name is Akua. I'm a U.S. licensed attorney focusing my practice exclusively on U.S. immigration and trademark law, representing immigrants in all 50 states throughout the United States, handling all types of U.S. immigration law matters. So let's take a look at the difference between an RFE and an RFIE. So basically, usually when you're submitting documents for filing, you would usually need to submit an initial set of evidence, and you can find this as part of the checklist of initial evidence required on the USCIS website. Okay, and so if you submit your application and the USCIS finds that there's an insufficient amount of initial evidence that has been submitted that would demonstrate eligibility for the benefit request that you're seeking, then they may issue an RFIE, which is a request for initial evidence. Usually an RFE, which is a request for evidence, is when there is generally insufficient evidence for eligibility. Okay, simply that. So let's take a look at an example. So for example, if you're filing an adjustment of status application for your mother and you're a U.S. citizen, you will be required to submit a birth certificate, your birth certificate, the petitioner's birth certificate, which will list the petitioner as the child and the beneficiary as the mother. Okay, so for example, if you submit an application for the adjustment of status petition and you fail to include the birth certificate, you may be issued an RFIE, because it simply means that there's insufficient initial evidence and you haven't even established your eligibility. Okay, however, you may submit a birth certificate, okay, but the USCIS may issue an RFE if, for example, the birth certificate is a delayed birth certificate, and usually they'll tell you that they're looking for a birth certificate that should have been issued contemporaneously with the birth of the child. And so if it's delayed, we're looking for additional evidence, such as school records, medical records, census records, affidavits that can bolster the fact that the beneficiary you are filing for is indeed your mother. Now, don't get too hung up on all the terms, because even sometimes an NOID, which is a notice of intent to deny, may be issued when all or most of the required evidence is also missing. So I've recently worked on a case for a client where they actually submitted, and it was a petition for an alien relative, and the petitioner was a green card holder and she was filing for her adult married son. And so in that case, she also needed to demonstrate eligibility with a birth certificate, and she did not do that. And so she was issued with the notice of intent to deny. Okay, so yeah, the sweetness of the pudding is always in the eating. Sometimes the USCIS will simply name a request whatever they want, a notice of intent to revoke, perhaps a notice of intent to deny, an RFIE or an RFE. So it's very important that you work with an experienced and efficient immigration attorney to uncover what the USCIS wants from you in order to get an approval. All right, friends, if you need my help, call me on 802-7800.